The Constitutional Court today has heard applications by the Independent Candidates Association of South Africa and One South Africa Movement, One SA Movement, about the constitutionality of the Electoral Amendment Act today. However, the Constitutional Court stated that it was wary of infringing on the separation of powers between Parliament and the judiciary. It's just one aspect that came out in court, but who knows about what else came out is Heidi Giokos, because she was in the Concord today. Heidi, welcome back. Just at a very high level, what were the main outcomes? What really was spoken about today in that court?
Yes, so it's a very important day. It's today and tomorrow, where you have a number of parties really arguing in terms of what they want this new Electoral Act to really entail. We do know that it was passed into legislation and signed by President Cyril Ramaphosa earlier this year, but independent candidates are arguing that they don't have the same playing field and the same level to contest in next year's general elections as political parties do. So we do know that independent candidates can contest on a national level, but it's how they can contest. So what Independent Candidates Association are arguing basically, Bradan, is that they want a 35-50 seat composition in Parliament. They don't want it to be 250 seats. So they want independent candidates to also be able to get a number of seats in Parliament should they be successful in being voted as an independent candidate wherever it might be, nationally that is.
Yeah, because currently the threshold is a bit steep for them.
Yes, so currently it's a bit steep for them, but also the steep part that you're talking about is that they are expected to get 15% of signatures in the area that they are contesting, or nationally, whatever the case might be. So they need to get about 15,000 votes, for example. Not votes, signatures. How are they going to get 15,000 signatures? It's different with votes. With votes, they could get 100,000 votes, or they could get 1 million votes, because votes are secret, signatures are not. And this is what independent candidates are arguing, that the threshold and the way things are set at the moment, the electoral system that's set at the moment, is not fair for independent candidates. So they are arguing that the threshold needs to change, so it needs to be a 350 seat composition in National Assembly, and the threshold needs to change in terms of not needing to have 15,000 signatures to be able to contest nationally come next year's election.
But as you said, the arguments will continue tomorrow in the Concord. But today, I mean, some of the respondents, some of the applicants had an opportunity to present their case, and the Home Affairs being one of them.
Yes, the reason why Home Affairs is one of them, Bradan, is because they are instructed to basically come up with this Electoral Act and to implement it. And if there are changes, so should the Constitutional Court rule in favour of what the independent candidates are asking for, it's up to the Home Affairs Department to enact this and to pass it. The Minister of Home Affairs, Aaron Motsoaledi, was in court today listening to arguments and, of course, listening to his legal team. His legal team is arguing that it does not actually make sense to change the threshold for independent candidates, and that it's going to cause complications, because you might have a situation where you have too many independent candidates and not enough seats in the National Assembly. And then what happens in that instance? We do know that the Minister of Home Affairs has been very critical in terms of saying that they have done everything they can. They've gone above board. They have not been delayed in terms of enacting this act that was passed earlier this year. But let's listen to what his legal team had to say in the Concord today.
The ICA does not object to three things. First, it doesn't object to the principle of there being two seats, regional and compensatory. Second, it doesn't object to the principle that independents can only compete for regional seats, whereas political parties can compete for both. I mean, when I say it doesn't object, it's very unhappy, but it doesn't suggest that there is anything unconstitutional about that. And thirdly, the ICA does not object to the fact that there are two ballots used and that both ballots count towards the second set of seats, which is what produces the unequal vote, if I can use it in inverted commas, or the unequal quota. So none of that is objected to. The only debate between the parties, and our learned friend Mr. Madonsela said so, he said the only debate between the parties is, did Parliament act unconstitutionally by reserving only 200 seats for which independents could contest? I thought he was suggesting it had to be all 400, but in answer to the question from the Chief Justice, it is clear. He says Parliament was constitutionally obliged to set aside 350. not 200. And that is the only debate between the parties. Did Parliament act unconstitutionally by adopting a ratio of 200 to 200 as opposed to adopting a ratio of 350 to 50? That is the only debate between the parties. Now, one would have thought on the face of it that that is preeminently a matter for Parliament. We're not talking about Parliament reserving 5 seats or 2 seats or something nonsensical. We're talking about 200 seats, half of the seats.
That's Stephen Bartlender there, representing the Home Affairs Department in that matter in the Constitutional Court regarding our Electoral Amendment Bill. Arguments will continue tomorrow.